The American Psychology Law Society Conference, March 2024, Misinformation. At the American Psychology Law Society Conference in Los Angeles in March of 2024, there were several references to the idea that when questioning a subject, investigators must move past, quote, psychologically manipulative tactics, end of quote, and adopt a science-based methodology to assess subject credibility. In discussions and publications, psychologically manipulative tactics are described as isolating the subject from others, exaggerating the legal consequences of the subject's behavior, making promises of leniency in return for a confession, conducting questioning for an exhaustively lengthy period of time, and creating false evidence. And there were references and innuendos by some that these were characteristics of the Reid technique, when in fact nothing could be further from the truth. In the discussion of what is a science-based methodology, there was recommendations that the structure of the investigative interview should include the development of cooperation via rapport and trust, the elicitation of information using productive questioning to enhance a subject's recollection, the use of strategic questioning and assessment of verbal or story-based cues to evaluate credibility, the strategic withholding of evidence as a way to identify statement evidence inconsistencies and resolve a subject's responses to discrepancies, all of which are the exact elements of the Reid technique process. Let me go through the essential elements of the Reid investigative process because people either don't understand it or are intentionally misrepresenting it in many cases. The Reid investigative interview process is called the Behavior Analysis Interview, or BAI. The Reid interview process is a non-accusatory, non-confrontational, information-gathering conversation. During the interview, it is essential that the investigator maintain a neutral, objective, non-judgmental, fact-finder approach. No accusations of guilt should be made during the interview process. All interviews should be conducted in accordance with the guidelines established by the court, such as the proper advisement of rights, securing the presence of a parent or guardian for a juvenile when the law requires that, etc. The interview should begin with casual conversation, securing some biographical information about the subject, maybe talk about what they do for a living, their job, a recent news event, a sports event, something of that nature, to engage in casual conversation in an effort to develop a behavioral baseline for the subject and some rapport with the individual. The investigator should use open-ended questions to develop the subject's statement, story, version of events, or explanation for what happened. Can you tell me what happened? What did you do? What did you see or hear? What were your activities during this time period? After the subject relates their initial story or version of events, the investigator will then ask a series of questions to develop additional details, as well as questions to expand on and clarify the who, what, when, where, why, how of the incident that is under investigation. During the interview, of course, the investigator will attempt to resolve or at least address any inconsistencies or contradictions that may have developed from prior interviews, from what the subject is saying, or from the investigative information. If the subject offers an alibi for the time period in question, every effort should be made to substantiate that alibi. We encourage investigators to follow the 80-20 rule. During the interview, the subject should do 80% of the talking, and we, the investigator, are doing 20%. During the course of the interview process, the investigator should observe the subject's verbal and nonverbal behaviors as a guide to the interview questions. It's important to remember that there's no behavior unique to deception. Just because someone doesn't look at us does not mean they're lying. Behavior must be evaluated in context and against the subject's normal behavioral pattern. There are many factors that can affect a subject's behavior that the interviewer or the investigator has to be aware of and consider. Culture, mental and psychological impairments, physical condition, the presence of alcohol or drugs, all of which can influence the subject's behavior. A subject's verbal and nonverbal behaviors are not substitute for evidence, but by observing them, it can help us identify when a subject may be less than candid during the interview, prompting us to ask additional questions, probe a little bit more carefully into a given subject matter, and as a result, we may develop incriminating factors or evidence. As a general interviewing rule, the investigator should not tell the subject what they know about the case, but instead ask an open-ended question inviting the subject to tell us their story so that we can then evaluate it. Is it consistent with what we know? Does the information we've already accumulated contradict what this person is telling us, etc.? In addition to the investigative questions, the investigator should utilize what we call behavior-provoking questions. These are questions that, as a general rule, most truthful people answer one way, most deceptive tend to answer a different way. Let me give you an example of 2 behavior-provoking questions from a child sex abuse investigation. The think question. John, did you ever think about engaging in sexual activities with any of the children here at the daycare facility? Answer. I think everyone working here has had thoughts like that. The second behavior-provoking question. Punishment. John, what do you think should happen to a staff member who would engage in sexual activities with any of the children here at the facility? Well, I guess it depends on how often it happened. The investigator should not reveal all of the details about the crime. It's critical to keep some details secret, so if the subject later on acknowledges they committed the act that we're investigating, and they give us those details which we had withheld, then it's corroboration of their involvement and of their guilt. The investigator should not show the subject crime scene photographs which may reveal some of the corroborating details. The investigator should evaluate the subject's possible involvement in the issue under investigation based on the investigation, case facts, factual information, and information learned and developed during the interview. The interview and any subsequent interrogation should be recorded. All investigators know this. I think some people on the outside, so to speak, do not know this or do not really consider this. The investigative questions are the core of the interview process, not the behavioral inquiries, but the investigative questions. As an example, John was found dead in his home on Saturday night. He had been shot in the head. John was a real estate agent and worked out of his home real estate office. He had several real estate colleagues who occasionally also worked out of his home office. As part of the investigation, John's colleagues were interviewed, one of whom was Dennis. When Dennis was asked when was the last time you'd been over to John's house, he said, gosh, it's been quite a while. It's been at least a month, maybe 5 or 6 weeks since I was last over there. Unbeknownst to Dennis, when the police canvassed the neighborhood, they found a lady who lived across the street from John who had been filming her kids that Saturday morning playing soccer in the yard. And in the background of the film, you could see somebody going up to John's front door, waiting for about a minute or so, and then going into the house. A closer examination of the film revealed that it was Dennis who went into John's house at about 10 a.m. on Saturday morning, the day of the murder. The fact that Dennis lied to the investigator about when he had most recently been at the house was obviously very significant, much more so than any behavioral observation during the interview. In our book, Criminal Interrogation and Confessions, we devote over 100 pages discussing the proper way to conduct an investigative interview. Here are the essential elements of the Reid interrogation process. Interrogation should only be conducted when the case investigative information indicates the subject's probable involvement in the commission of the crime. And then the purpose of the interrogation is to learn the truth about what this person did, said, or might know. The investigator should conduct all interrogations following the guidelines established by the courts, the proper advisement of rights, presence of a parent or guardian for a minor, etc. The investigator should not make any promises of leniency, threats of harm, or threats of inevitable consequences, or certainly never physically abuse the subject. The investigator should not conduct interrogations for an excessively lengthy period of time. Some research has suggested that the median length of time for false confessions is over 16 hours. The investigator should not deny the subject any of their rights during the course of the interrogation process, and should not deny the subject the opportunity to satisfy their physical needs. In a non-custodial interrogation, where the person is there voluntarily, the investigator should make sure not to deprive them of the opportunity to walk out if they want. The investigator should exercise special caution when questioning socially immature juveniles or individuals with mental or psychological impairments, and should not misrepresent evidence to any of those subjects. When a suspect claims to have little or no memory of the period when the crime was committed, the investigator should not misrepresent incriminating evidence to this individual. And of course, the investigator should never manufacture evidence implicating the subject. The central focus of the persuasion process is to propose to the subject reasons and motives that will serve to psychologically justify or excuse their behavior. Not legally justify, but psychologically justify. When the subject acknowledges what they did, the investigator should ask open-ended questions to develop the corroborating information: the location of the murder weapon or the bloody clothes, how the subject gained entry into the building, where the subject sold the stolen jewelry. Corroboration is an essential element to establish the authenticity of the statement. And the interrogation, of course, should be recorded. The subject's confession now is not the end of the investigation. The investigator should continue to develop additional details about the subject's behavior before and after the commission of the crime, and to verify the details of his statement of involvement. All investigators should adhere to the following principles: always treat the subject with dignity and respect, always conduct interviews and interrogations according to the guidelines established by the court, do not make any promises of leniency, do not engage in physical abuse of the subject, do not make any threats of harm or inevitable consequences, do not conduct interrogations for an excessively lengthy period of time, do not deny the subject any of their rights, and do not deny the subject the opportunity to satisfy their physical needs. And exercise special cautions when questioning socially immature juveniles or individuals with mental or psychological impairments. We publish on our website the Reid policy recommendations regarding misrepresenting evidence during an interrogation. Here they are. Investigators should consider the impact that misrepresenting evidence to the subject may have on a jury's or court's perception of their credibility. Investigators should be sure to check with their local prosecutors as to their views and recommendations regarding misrepresenting evidence to a subject, and should be familiar with court decisions in their jurisdiction. Investigators should not misrepresent any evidence to a subject who acknowledges he may have committed the crime but has no specific recollections of doing so. And as we said shortly ago, should not misrepresent evidence when questioning a youthful subject with low social maturity or someone with a diminished mental capacity or psychological disability. Investigators should not use deception to threaten inevitable consequences, and should never fabricate evidence or lie about potential leniency. Given current judicial and legislative trends regarding the use of deception during an interrogation, investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. As previously mentioned, there are several states that have enacted legislation that prohibits investigators from lying to juveniles about evidence. In our policy position statement, we have a list of those states, which you can access on our website. That's the name of the article. We have a number of different documents that you might find of value on our website: false confessions, the issues to be considered, what questions should be asked to determine the voluntariness and validity of a subject's confession, qualifying misrepresentations about interrogation techniques, and the testimony of false confession experts. And the link that you see on the screen will take you to a number of those articles. I want to thank you very much for taking a few minutes to listen to this presentation.